May I please, Your Lordship?
Yes,
I have filed here to IA, Your Lordship. Your Lordship, while issuing notice on 59, making returnable within 4 weeks, stated that interim pay will be considered after 4 weeks. But during the pendency of the writ petition, they have shifted the site, Your Lordship. That's why I have filed IA day after tomorrow, Your Lordship.
Friday.
Right.
May I please, Your Lordship? My lord, I beg to mention for a listing for a IA for correction of an order, my lord. Tomorrow, my lord, that fetus termination matter, instead of 21 weeks, my lord, it has been recorded as 28. So therefore, the JMCH authorities, tomorrow, my lord, oblige, my lord.
May I please? Also, I am paying for listing of a case on tomorrow, Lordship, for motion, Lordship.
What is the matter?
This matter leads to land acquisition matter, Lordship petitioners.
Friday. Friday.
May it please your lordship. I beg to mention for listing of a WPC matter for withdrawal. Matter
When do you want?
tomorrow, my
All
lord.
right.
Oblige.
May it please your lordship, I beg to mention for listing of admission
Hmm.
or the matter is related to land,
Hmm.
settlement of land.
Hmm.
Lordship,
Third week of
I-
November. Yes. Put the date, third week of November.
May I please your lordship? Lordship, item number 2, I have instruction from petitioner, Paritos does, I withdraw the case.
Item number,
2.
Well, the stay order is there that may be vacated.
yes, your name, please.
Ms. S. does on behalf of R. Goswami.
Mr. R. Goswami, learned counsel for the petitioner submits that he has instructions from his client to withdraw this writ petition. Mr. K. N. Chaudhary, learned senior counsel appearing for the respondent number 4, submits that he has no objection to the prayer, but the interim order passed earlier be vacated. Taking note of the submission made at the bar, this writ petition stands disposed of on withdrawal. Interim order passed earlier shall stand vacated.
For admission, I can want.
But this is the matter which relates to the steps to be taken under the Disaster Management Act. They have filed an affidavit now. They have filed an affidavit, huh?
Yes.
As per your lordship's order dated 25th.
Affidavit has been filed.
Lordship,
They have.
When filed, when?
it is 610 law, it is a record.
It's on record, I suppose.
610. Interestingly, the private respondent there in Melon has also filed a writ petition. It was filed as received by us yesterday. He challenges the orders passed by the additional deputy commissioner under disaster management. So it is not numbered. I was just going to the petition. Vikas Agarwal, wherein Melon the petition is erred as respondent number 9.
We have not been served, we do not know, of course. Well, just to
Maybe
avert,
it will come tomorrow. For this
just
motion.
to avert.
Just a minute. Where is the affidavit dated 6/10? Is it on record?
Lordship, পড়ার record, I have second and then. Record তো দেখাই যাবে। দেখাই যাবে কিন্তু।
Little faster, Mr. Goswami.
Sorry.
Little faster.
No, Lordship, sorry. Not the record, Lordship.
Hmm?
Not the record, Lordship.
Not in the record. Then he's saying it is in the record.
No, I'm saying that a different petition has been filed
Hmm.
by the respondent there in Melon. Wherein Melon, the petition has been erred as a respondent. And we received copies of this written yesterday. I was just going to, maybe it will be registered today and will come for motion tomorrow.
Whether,
What has been stated in the affidavit?
well, they have said that they have issued another notice, this is a vulnerable position. And they have again issued a notice to them that you immediately within 7 days, you take the corrective measures as was suggested earlier, else we will proceed otherwise. That
So
is,
then there is no hurry. They are taking action in the matter. Read court will not say
similar
anything.
orders, well, my anxiety is similar orders has been passed right from 2020.
No, that's right. But we'll see what happens here.
Thereafter also, prior to your lordship's order, another collateral bench issued.
Mr.
a similar
Mohanto, the
charge.
court cannot presume that in terms of the order of the court, they have issued notice, but they will do nothing. That presumption is not possible.
Presumption, I am not asking this honorable court to break,
So what is the order you are seeking today?
but I want that the state authorities have the responsibility to take it on their own if he fails to
All
do.
right, we'll see those matters, not now. not this.
Repeatedly asking and he is defying.
We have given you 7 days. Today is the last day.
Today is the last day.
So they let the registry tag the affidavit and list again.
List day after tomorrow.
No, day after tomorrow, not possible. What is such earth-shattering urgency in this?
My lord, if again,
Ah.
lordship has seen the weather, if
No,
it starts
Mr. Mohanto,
raining heavily,
please
then
be
there is,
reasonable.
my lord, that
We
is not-
also know what is the weather here.
my lord, that is.
You don't
it
think the
it is
court doesn't
most
know the weather
unpredictable Now, it is most unpredictable now.
All right, all right. We'll
That
have
is
it after
the-
vacation. These are not that urgent matter. Let them take action. If they don't, then we'll examine it.
Enough time has passed. That is why I am asking your lordship. Enough time has passed.
Mr. Mahanta, these are not matters to be finally heard and decided just before the vacation. Particularly when they have issued a notice asking him to take corrective measures.
So lordship may,
Hmm.
in that case, say that they will pursue it. If it is not done by today,
Mr. K.K. Mahanta, learned senior counsel assisted by Mr. A. Begum, Ms. A. Begum, learned counsel is present for the writ petitioner. And Mr. N. Goswami, learned G.A. Assam, appearing for the respondent number
2, 3 and 6.
Respondent numbers 2, 3 and 6 submits that in terms of the order dated 25/9/2023, the Deputy District Commissioner Kamrup, is it? Who has
Additional
filed the affidavit? Additional
lordship
additional district.
Additional District Commissioner
and
Kamrup
CEO District Disaster Management
and
Authority.
CEO District Disaster Management
Authority.
Authority has filed an affidavit on 6/10/2023, bringing on record a copy of the notice by means of which the private respondent has been asked to take corrective measures within 7 days from today. First up, however, I find that the affidavit is not on record. Um, Considering the nature of grievance expressed in this repetition, since the concerned authority has already taken steps for ensuring safety of the zone under consideration, this court is of the opinion that they must be allowed some time to bring the said process to its logical end. As such, a registry to list this case again immediately after reopening of Puja vacation by tagging the affidavit dated 6/10/2023 with the record of this case. The petitioner would be at liberty to file rejoinder and oblique or additional affidavit on or before the next date fixed, bringing on record new developments, if any, in the matter. Who else is appearing? Mr. B.K. Das, Learned Counsel. Mr. D. Gogoi, Learned SC Forest Department, Assam, is present on behalf of respondent number 5. Mrs. R.S. Deori for respondent number 4, serially available, and Mr. B.K. Das for respondent number 7. Ms. G. Hazarika, SC Revenue for respondent number 1. So you are representing the private respondent. You filed a writ petition challenging that. What is the purpose in it? Why don't you take corrective measures, whatever has been said?
I'm ready to construct a wall mount. The basic concern here is that the other side wants to construct the RTC retaining guard wall. There is that the fact hearing is that there is.
All right, we'll see when the matter comes. But these are things the writ court cannot go into. Yes,
My lord, let it come up on 9th, my lord, October.
yes, on the request of Mr. Mahanta, this matter is directed to be listed again on 9th of November. not
November,
October.
sorry.
Yes.
Apply.
I pray for adjournment of the case, maybe after vacation. This matter.
After vacation, Mr. Jiuddin Learned Counsel for the writ petitioner 6 adjournment in the matter with a request to post this case again after reopening of the Puja vacation. Mr. R. Dubey, learned, Standing Council, State Election Commission, appearing for respondent number 3 is present and does not have any objection. Similar is the stand of Ms. R. Burwa, learned G. Assam, and Mr. P. Henrik, learned SC PNRD Assam, appearing for the official respondent. In view of the request made by the petitioners council, this matter stands adjourned for 3 weeks, list again after the reopening of puja vacations.
Keep all. I am in 5 euros.
Yes.
Issue is same euros. The petitioner, your lordship, are all your lordship. Shareholders, your lordship, of Rupaguti, your lordship, Samabaya Samiti Limited, your lordship. Now, what has happened here, your lordship? The facts are like this, your lordship. Initially, your lordship, the private respondents. Now, your lordship, 18 numbers, your lordship. They are
Just a minute, Mr. Bosakut. You are in WPC 5400.
lords.
And who is in the other matter?
Right.
Just take your seat for me. So the AGM election has been held on
Held, your
17th.
lordship, but since your lordship has passed
Hmm.
an interim direction, it has not been approved.
So your case is that the private respondents cannot participate in the
Lordship, that
election.
is my case, your lordship.
And what is the case in the other matter?
Same,
Same.
same.
Why you say they cannot?
I
participate?
say, your lordship, before, basically, your lordship, my case is that, your lordship, the section 41A, your lordship.
Act.
Read with section bylaw 23. A, your lordship.
Why this earlier board was dissolved?
Earlier board, your lordship, they could not, your lordship, held meeting, annual general meeting within a stipulated period, your lordship. Therefore, your lordship, by operation of law, it got dissolved.
Which is the section?
Lordship, that's your lordship. 39, your lordship.
Yes, 39.
May I read your lordship?
Yes.
A general meeting to be termed as annual general assembly of a registered cooperative society shall be held at least once in every cooperative year within a period of 6 months of close of financial year to transact the business as provided under this act. The board shall automatically stand resolved for not holding annual general meeting in accordance with the provisions of the act and bylaws within 6 months from the expiry of the every financial year.
So why they can't take part in the subsequent AGM?
Lordship, your lordship, 41.8, your lordship may kindly come.
41(8).
41.8. The directors shall not be eligible for re-election if so specified in the bylaw. Now, if your lordship, bylaw extra copy আছে? In bylaw, your lordship, 23,
Where is the bylaw?
bylaw, your lordship, tomorrow, your lordship may candidate.
Hmm. 23.
23, lordship,
You don't have a copy, is it?
lordship, that's.
We'll have it after vacation. Sorry.
No,
I
your
can't
lordship,
conduct
there is
it.
an interim order.
Interim order.
Sorry?
Interim order is operating. The board, my lord, which has come about now,
No, but he is not even prepared. He doesn't have the books.
my lord.
Otherwise,
This is
everything
the
else. is-
standard High Court hearing has gone down now. No list of books, no books, nothing.
Interim order is in his favor, my lord.
That's.
Elected body now, my lord, is handicapped.
All right, you run the risk. I may not be able to appreciate your point, but the judgment will come. Yes. Place it, whatever is the argument.
Lordship, that is there in the 23, your lordship, saying that if your lordship, the board is dissolved, your lordship, due to failure to hold additional annual general meeting, your lordship, the board of directors will not be eligible.
Please
for
read it, which provision, please read it.
23, your lordship. Point 4, your lordship, these are the two provisions, your lordship.
So that is your case.
Lordship, that is my case, your lordship. Before that, your lordship,
Who are, they are all elected, is it?
they were elected earlier, your lordship,
No, the private respondents have been elected in the,
elected,
all of them.
all of them, your lordship. Now, what had happened, your lordship,
Hmm.
the
No, just a minute. Respondents 6 to 10 in your writ petition. 6
Lordship.
to, not 10, 6 to
to your lordship,
15.
lordship,
They have all been elected in the
Lordship.
AGM held on
Is the-
17/9.
7 to 13.
7 to your lordship.
7 to 13 and others did not participate. They were permitted but not participated.
My lord, may I clarify?
No, you do
The-
it. your
No,
time.
no, what I'm trying to say, the election AGM held 17th, my lord. That result, my lord, is not declared and it is, my lord,
No,
known to nobody.
no,
Because
it
your
is
lordship
prior
has
to-
stayed it, my lord. Approval is stayed.
Yeah, but they have participated.
They have participated.
So that's his grievance. They
Yes,
can't participate.
That
Yes,
is,
yes.
that is my grievance.
yes.
Then-
No, my lord, because what is coming is that they are elected, my lord, because they are.
That's all right.
That is
Yes.
prior
They
to,
are may or may not be elected,
Yes.
but even if they are not elected,
Yes, yes, they have participated, correct,
their participation will it vitiate the election?
Ah.
If they are not eligible to take part,
yes.
then allowing ineligible persons to participate in the election,
Yes.
will it not have a vitiating effect in the process?
My lord, that he has to my lord, satisfy your lordship, that part.
No, that's why we said you take your seat, let him
Yes,
finish.
yes, correct, correct.
Yes.
now, your lordship, what has happened here, lordship, your lordship, initially, your lordship, for not being present in 3 consecutive meetings, your lordship, their directorship was, your lordship, declared to be invalid, your lordship. Then they made an appeal before the register, your lordship. And if your lordship comes to your lordship, page 45, your lordship. This is the, your lordship, appeal, your lordship, they have preferred, your lordship. Against your lordship. Declaration of their. Directorship as invalid, your lordship, and in view of that, then appeal is preferred, your lordship, and. Page 55 is the order of the register, your lordship. 27/4/2023.
Hmm.
27/4/2023, your lordship.
Yes.
This is the order, your lordship. May I read, your lordship?
Please read the operative part.
Lordship, it is clear from the aforementioned facts, penultimate paragraphs, your lordship. It is clear from the aforementioned facts, 2 valid board meetings were conducted on 28/11/2023 and 30/11/2023, which were not attended by the above mentioned 8 directors of board, and no valid 3rd meeting has been conducted. Moreover, it has been observed that on 28/11/2023 and 30/11/2023, that is within the period of 3 days, 2 board meetings were held. Whereas it is mandated by bylaw of the society that minimum 4 days prior notice should be given to the members of the BOD for a board meeting. Therefore, the disqualification to continue in the office of director of the board as invoked by section 43(7) of the Assam Cooperative Society Act 2007 does not apply in this case. Therefore, the directors of BOD, Dhupguri SS Limited, so and so, so and so, so and so. These are the persons named, your lordship, hereby allowed to continue as director till completion of the term subjected to the facts they are otherwise not disqualified under any other section of the Act of 2007. Now, your lordship, this order was put to challenge, and the honorable court, your lordship, negated the challenge, your lordship. That is, I have annexed that page 56, your lordship. The operative part, your lordship will find your lordship. Finding of the honorable court from para 10, your lordship, but ultimately it was negated, your lordship. Then your lordship, what had happened, your lordship? On 3/5/2023, they have submitted your lordship application for
The
holding.
Writ petition was dismissed.
Writ petition dismissed, your lordship.
Who filed the writ petition?
These are your lordship,
Private.
not some of the your lordship members who were inducted as your lordship in the board of directors, your lordship, in place of them. They put this to challenge, your lordship. Now, your lordship, they on 3/5/2023, these members, your lordship, asked for a meeting of the board of directors, your lordship. Now, when it was asked, your lordship, the secretary initially said that since we have not received the copy of the order of the register, we are not holding it, but ultimately on 12/5/2023, your lordship will get it at page 73. 12/5/2023. Page 73. The
Yes.
secretary, your lordship, meeting of board of directors were called, your lordship. And the agenda, your lordship, were taking seat by chairman, discussion about the forthcoming AGM election and correction of voter list, remarks, and this, your lordship. Now, your lordship, meeting could not be held, your lordship, although they were present in the meeting, all these persons, your lordship. Your
But
lordship.
all these things are these relevant now. Only question is.
Yes, your lordship, because
Right.
ultimately, because your lordship, if we go through the order, your lordship, we will find, your lordship, they have been allowed to participate in the election on the ground that probably, your lordship, that in holding of AGM and the board meetings, your lordship, these people has no role, your lordship. That is apparently, your lordship, from the perusal of the your lordship impugn order. Therefore, your lordship, this observer's note is important, your lordship. That is at page 79. On 16/5/2023, I was present in the meeting convened by the Board of Directors of Dhupguri Samabay Samiti Limited. In the said meeting, a discussion was held regarding voter list, and it is seen that Secretary has already finalized the voter list by 10th day of May 2023. As per the provision of Assam Cooperative Societies Act 2007, there are 4,224 numbers of eligible voters, 340 numbers of invalid voters, and 248 numbers of voters are there. It was also discussed with the secretary regarding accounts. It is found that cashbook, this part is, your lordship, not necessary. Then on 15/5/2023, I, as the observer of the meeting of the board of directors, saw the president and the members of the board of directors in front of the office who were coming out from the conference hall at about 11:30 AM. And when Abdul Kalam, the president, was asking about the meeting, the president told that due to uncontrolled situation, the meeting had to be cancelled. Thereafter, on being inquired the matter, it could come to our knowledge that an untoward incident had occurred in the meeting, as Mainul Haq, along with 7 other members, tried to make a video in front of media persons while submitting written self-prepared proposal before the board. As the situation was out of control, the meeting was adjourned and declared cancelled. As an observer, I'd like to say that as per the provision of Assam Cooperative Societies Act 2007, amended in the year 2012, the full responsibilities are given to the secretary and president of the Samabay Samiti to forward the proposal of the Assistant Registrar of Cooperative Societies, Nagaon, regarding preparation of voter list, fixing the date and place for the forthcoming annual general meeting. Now, meeting could not be held, your lordship, due to the chaos created by the private respondents, your lordship. Now, your lordship, that has been observed, that is the report of the observer reveals that, your lordship. Thereafter, your lordship, we again, a meeting was not we, your lordship, the Samabay Samiti again held a meeting, your lordship, on page 83. And that could not be held, your lordship, due to lack of quorum, your lordship. Page 84, as the quorum of the meeting is not constituted. Then your lordship will find at page 86, by operation of law, your lordship, section 39, your lordship, the committee was dissolved at page 86, your lordship. Then your lordship, these persons, your lordship, filed an application before the register, your lordship. making a prayer for allowing them to participate in the election, Your Lordship.
Yes.
Now, Your Lordship, they made a prayer, and Your Lordship, page 90 is the impugn order. Now, first line itself, Your Lordship, peruse the order of the Honorable Guwahati High Court dated so and so in WPC number so and so filed by the so and so and so and so, Your Lordship. Now, Your Lordship, that order, Your Lordship, that is the order by which the earlier order, Your Lordship, or register was put to challenge, Your Lordship, which was negated, Your Lordship. That matter has closed at that point of time. But this order, a petition has been submitted by Wajida Khatun and 7 others praying for permission to participate in the forthcoming AGM election of Dhupguri Assets Limited regarding alleged illegal disqualification of 8 numbers of BOD members by the chairman and the secretary, Nazrul Islam. In this regard, a hearing was conducted on 29/8/2023 in the office of the Registrar of Cooperative Societies, Assam. The hearing was attended by Chandan Mishra, ICARCS Nagaon, Hiteshwar Teron, Senior Inspector Auditor CS Morigaon, come Departmental Officer, the name of the persons, Your Lordship. Then heard the petitioners and the respondents, peruse the documents submitted by the parties and the report submitted by the ICARCS Nagaon. It is found that the chairman had illegally disqualified 8 numbers of directors of BOD, namely Azizul Haq, Mujibur Rahman, Mohammad Azizul Haq, Mohammad Moinul Haq, Wajida Khatun, Waizul Haq, Chaudhary Saleha Khatun, Muslim Uddin, due to absent in BOD meeting held on 28/11/2022, 30/11/2022, 2/1/2023 consecutively. It is also found that the chairman of the Dhupguri Assets Limited willfully and deliberately neglected the process of holding the AGM election Dhupguri Assets Limited in due time. Moreover, it is seen that Wajida Khatun and 9 others had approached the chairman, secretary Dhupguri Assets Limited, as well as the assistant registrar of Cooperative Societies Nagaon to convene a BOD meeting to discuss about the holding of AGM election of the society, but no action was taken in this regard. In view of the above, in consideration of all aspects, I, Sri Narayan Kaur, IAS hereby allowed the petitioners so and so, so and so, so and so, along with the other BOD members who are otherwise disqualified under section so and so, to participate in the forthcoming AGM election of Dhupguri Assets Limited, scheduled to be held on so and so. With this, the petition filed was now on the strength of this, Your Lordship, they participated in the election process, and we have put this to challenge basically on 3 grounds.
You have challenged 01/09/2023
Lordship,
in this writ petition.
Lordship, 1/9/2023. Now, basically, Your Lordship, our case is this, Your Lordship. First, Your Lordship, is that register, Your Lordship, first of all, has no power to pass an order of this nature, Your Lordship. Now, Your Lordship, no power is vested on the register, Your Lordship, to pass such an order, Your Lordship, by the statute, Your Lordship. Number 1, this is not an appellate order, Your Lordship. It is simply an application filed by the authority. He has an appellate order which he can exercise, Your Lordship, against an order passed by some of the government officer or any other subordinate officer, Your Lordship. But this is not an appellate order. He has referred to a particular order, Your Lordship, Honorable High Court, Your Lordship, which has no relevance in the present case. That is, Your Lordship, relating to a, Your Lordship, order, Your Lordship, revoking the disqualification of some of the board of directors, Your Lordship. That has no relation with the participation of the election, Your Lordship. But in spite of that, reference was made to this particular order of the Honorable Court, Your Lordship, as if, Your Lordship, there is something, some relation is there between the order of the Honorable Court, Your Lordship, in WPC number, Your Lordship, 2595 and the present order, Your Lordship. That is number 1. So he cannot go, ultimately, Your Lordship, register is a creation of a statute, Your Lordship. And he, therefore, Your Lordship, in my humble submission, he cannot go travel beyond the power conferred expressly provided by the statute, Your Lordship. Now, if Your Lordship sees, Your Lordship, The statute only says, your lordship, 41(8), your lordship. The director shall not be eligible for re-election if so specified by the bylaws. And there is no proviso, etc., either in the bylaw or in the statute, your lordship, which empowers the registrar as an authority, your lordship, to pass such an order. Ultimately, your lordship, the amounts to, your lordship, amending.
Who are the petitioners in your case?
This is the, your lordship, shareholders, your lordship.
Shareholders. And in his case?
And we have participated in the election, your lordship.
You have participated in the election.
We have participated in the election. Your lordship. Now, your lordship will kindly see, ultimately, your lordship.
Counting has taken place already.
Counting taken place, your lordship. Approval, your lordship, has not directed not to be granted. And your lordship, the one-man committee from the.
So supposing your argument is accepted, what is the relief you are seeking?
Lordship, then your lordship, fresh election will have to be held, your lordship. And secondly, your lordship will kindly see whether, your lordship, these persons are eligible for participating in the election or not, your lordship. This is an issue to be decided by the returning officer, your lordship. Ultimately, your lordship, it is related to election, your lordship. Returning officer, while accepting.
Who is the returning officer?
Returning officer, your lordship, the register, your lordship, appoint person as a returning officer, your lordship.
So was this plea raised before the returning officer?
No, your lordship, we came before this honorable court, your lordship. We came before this honorable court, your lordship. Once, your lordship, nomination process was started, your lordship. Now, your lordship, since if we did not, your lordship, even we cannot, your lordship, since order of the register is there, your lordship. When order of the register is there, returning officer cannot go beyond that, your lordship. So whether we raise it or not, your lordship, it will make no material difference, your lordship. Ultimately, we will have to put it to challenge. Now, the authority to be exercised by the returning officer, your lordship, usurped by the register, your lordship. Neither an appellate authority, nor he has power vested on it by the statute, your lordship. And he being the creator of the statute, your lordship, he cannot go beyond, your lordship, the provision of the statute. If it specifically, your lordship, specifically empowered by the statute to pass an order, your lordship, then, your lordship, yes, he could have, your lordship. That power is not there. And your lordship will kindly see, this is not an appellate power also, your lordship.
That you have argued.
Yes. Then secondly, your lordship, so far as the board of directors, responsibility of board of directors is concerned, your lordship will find, your lordship, this is a collective responsibility, your lordship. If, your lordship, for some reason, your lordship, the chairman or the secretary is not holding the meeting, your lordship, they have courts available for them, your lordship, under the act, your lordship. If your lordship takes up.
All right, so anything else? Any decided case law you want to rely on?
On the, your lordship, first point I have on one case, your lordship. Oh, yes. Your lordship, before that, can I, your lordship, make one more submission, your lordship?
Yes.
Lordship. It is, your lordship, that is, your lordship, 43 to, your lordship may kindly take up, your lordship, the act, your lordship.
43
2. It says, your lordship, the president or chairman, and in the event of his being physically incapable of acting, the vice president or vice chairman may, whenever it thinks fit, call for special meeting of the board and shall be bound to do so within 15 days of the date of receipt of written requisition signed by not less than 1/3 of the directors of the board, your lordship. Now, your lordship, they could have, your lordship, even assuming, your lordship, that these people are not holding meeting. That course was open for them, your lordship. So therefore, your lordship, my humble submission, your lordship, ultimately, this is the collective responsibility of the board of directors. A section of the board of directors cannot, your lordship, say that we are not responsible if they have not held the meeting.
Yes.
Lordship. These are your lordship on facts, your lordship. These are my submission, your lordship. And your lordship, so far as this impugn order is concerned, your lordship, therefore your lordship is bad, your lordship. And your lordship, he could not have, your lordship, pass this order,
Yes, let us see the decision.
lordship.
What is it, on which point?
On the point that your lordship probably not required, your lordship, the register being the creation of a statute cannot go beyond what is provided, explicitly provided in the statute. Your lordship. That's the
Yes,
point.
Mr. Talukdar.
My lord, the last election was held on 24/6/18. So therefore, the election AGM, my lord, was required to be held before expiry of 5 years term, that is by 23/6/2023. So that, my lord, was not held. Now, before proceeding further, in fact, my lord, under the act, my lord, there are two requirements. And for non-compliance of those two requirements, the twin consequence is, my lord, dissolution of the board and incurring of disqualification by the board members. Now that two provisions your lordship will find under section 39. 39 is in respect of AGM. And section 41(2) is in respect of election AGM. So these two requirements, 39 yearly AGM, my lord.
41(2) or 41(8)?
41(2). 41(2) is the requirement of holding the election. 41(8) is the consequence, my lord. Now, under 39, the requirement is of holding, my lord, yearly AGM by within 6 months from the date of closure of the financial year, that is by 30th of September. So non-compliance will follow the consequence under 39. And 41(2) says, before expiry of the board, the outgoing board has to conduct the election so that the incoming board can assume the office. So by 23/6/23, the 41(2) was required to be, my lord, complied with. So these are the two consequences, my lord, for non-compliance, entailing, my lord, dissolution and disqualification. Now, having said that, the disqualification your lordship will find under section 40, subsection 4A. This is the genus, my lord, and which has been discussed by division bench of this honorable court. I'll come to that later on. Now, 44 subsection A, it says, my lord, the period of 5 years has elapsed. This is regarding eligibility for a director in cooperative society. So 4 says, unless 5 years have elapsed from the date of seizing the director for A, my lord, for not conducting or wrongly conducting the annual general meeting under section 39. This is one, my lord, a disqualification. And the other for not holding the election is under 44E, automatic dissolution under subsection 4 of section 41. If your lordship comes to subsection 4, this consequence will follow for not complying, my lord, 42(1), subsection 41(2). Where a board fails to arrange for holding election of the directors or delegates, as the case may be, before expiry of the term of the office in accordance with the Act and bylaws, all directors shall cease to be directors on expiry of the period as specified in 42(1). So 4 will follow once, my lord, 41(2) is not complied with. My lord, am I clear? Yes. Now, here what has happened, my lord? Everything started, my lord, from November 22. I'm going by the, my lord, case of the petitioners. In para 4, there is, my lord, discussion about the no confidence meeting. So the chairman was sought to be removed. My lord, two factions came about. Subsequent thereto, 3 meetings were held, my lord. And in neither of the meetings, my lord, one of the faction appeared there too. So eventually on the third meeting, 12-1, my lord, 12-1-23, the chairman, my lord, inducted 3 members. It is, my lord, permissible under the act, my lord, to co-opt, including petitioner number 12 hearing.
Mr. Talukdar, I'm sorry to interrupt you.
My lord.
These are not relevant here. You may be arguing this thing, but these are not relevant.
Right.
The only two things which will be relevant and govern the outcome of this process is, as he has raised this point, first of all, under which provision of law has the register exercised this jurisdiction?
Right.
This is number one. Number two, if the law says on happening of these events, there is an automatic disqualification.
Right.
Where is the power to condone that?
Right.
You have to show me, and that power has to be specifically recognizable to some statutory provision.
My lord, correct.
So the answer to both the question is one and the same.
My lord.
What has happened 6 months prior to that, what is going to happen tomorrow are all different issues. If you didn't have the power, the order will go, the election will be set aside,
My lord,
and the direction will be to hold a fresh election.
correct.
Where is the power? Why didn't you argue on that?
Yes,
The power is not there, whatever be decided.
correct.
Doesn't matter.
Yes, my lord. In fact, why I was trying to draw the facts, my lord, because these are identical to the facts before the division bench. So that's why I thought, my lord, that will, my lord, in fact, be more
What
confident.
is, which decision, division bench?
Division bench, there is division bench judgment.
What
Where,
does it
yes,
say?
I'll please that.
Hmm.
My lord, the division bench has carved out an exception under which, my lord, the members can be allowed, the defaulting members can be allowed to participate, my lord, in the election, my lord.
Hmm.
So therefore, my lord,
Yes, then let us
yes,
see the
correct.
judgment.
I'll place it, my lord, right now. Yes. Case number to hold, tomorrow, writ appeal 31/19. Ase, ase.
Is it a reported judgment?
My lord, perhaps reported, in Monopatra it is reported, my lord, but writ appeal 31/19. In fact, if your lordship comes to para 10, from 10 onwards, your lordship will find more or less, my lord, the facts are identical. And section 44 subsection has been discussed, my lord. Now I take your lordships to para 10.
Hmm.
Lordship has got it, my lord. Internal page 23 of page 32. It is seen from the pleadings that the board of directors, including both the appellants, there are 2 appellants, my lord, were elected on 2011-16, and the said results were approved by the Assistant Registrar of Cooperative Societies on 23/11/16. In terms of section 42 of the Act of 2007, the term of the board of directors of Cooperative Society and its office bearers will be 5 years from the date of election. Under provisions of section 39, as discussed above, the annual general meeting is mandated to be held at least once in every cooperative year within a period of 6 months from the date of close of the financial year to transact the business as provided in this act. In the event no annual general meeting is held as mandated, the board shall automatically stand dissolved for not holding the annual general meeting in accordance with the provisions of the act and the bylaws. From the pleadings, it is not discernible as to the date for the close of the financial year of the society. Ordinarily, 31st March is considered to be the close of financial year. In some cases, 30th September is also considered to be close of the financial year. The dispute between the 2 rival groups arose due to the failure on the part of the appellant in WA 33/19, namely Bakhtar Hussain, to convene a special meeting or a meeting to discuss the no confidence motion against him as requested in writing by the appellant in WA 31/19, namely Jaharul Islam along with the other members. The matter traveled to the register of the cooperative societies. While allegations and counter allegations were being made against each other by the rival parties, what perhaps was lost sight of by both the appellants and their followers was the mandate. I'm sorry.
Yes, yes.
Yes. From the top, my lord, and counter allegations were being made against each other by the rival parties. What perhaps was lost sight of by both the appellants and the followers was the mandate under section 39 of the Act of 2007. What my lord, division bench says that they were fighting, and eventually, my lord, it was the 39, my lord, got, my lord, lost of sight. The provisions of 39 of the Act 2007 specifically mandates that there shall be an annual general meeting in at least once in every cooperative year within a period of 6 months from the close of financial year to transact the business as provided under the Act. Section 32 and 33 of the Act provides for general meeting and special general meeting respectively. As discussed above, the dispute between the two rival groups essentially was the failure of the chairman and the vice chairman of the board of directors to hold a special general meeting as requested by the appellant number so-and-so and his fellow directors. The allegations and counter allegations against both the groups was to the effect of justifying that the special meeting sought for them by the written requisition could not be held because of several intervening reasons, including the interim order dated so-and-so by this court in WPC so-and-so. However, in the tumult that arose between the rival groups was lost sight of the mandate under Section 39 of the Act, which provides for holding of an annual general meeting at least once in every cooperative year within a period of 6 months of the close of the financial year, and the automatic dissolution of the board to failure to hold the annual general meeting as mandated under the section. The annual general meeting not having been conducted, admittedly as is evident on the facts of the case, the board stood automatically dissolved. In Shahirul Islam, the following questions of law arose before a coordinate bench of this court. My lord, this is with regard to Section 39. Lordship may skip it. Section 39 was, my lord, considered to be a mandatory provision. And in para 11, Lordship may skip also. Here, the Honorable Division Bench had upheld the dissolution of the board. Now, from para 12, the Honorable Division Bench, my lord, proceeded to consider the disqualification, which we are concerned with, my lord. So if your lordship comes to para 12, this is important. Having said that, on the facts of the case, we do not find that the embargo under Section 40A is attracted in respect of the appellants as well as other members of the erstwhile Board of Cooperative Society. The embargo under Section 44A is essentially for not conducting or wrongly conducting an annual general meeting or special general meeting or board meetings. The term conducting a meeting is not defined under the Act of 2007. Recourse to the dictionary meaning is therefore required to be made in the absence of any specific definition prescribed under the Act. 12.1. The Major Law Lexicon, 4th edition, 2010 defines conduct as conduct means nothing else than control. The word conduct imports an idea of management, a guidance and overall supervision. Conduct is wide enough to include and is synonymous with both manage and control, and manage as it seems means an overall supervision even to the details of solving the problems as also take the details decisions. Raja Mahapatra so-and-so. The Chambers Dictionary 1983 edition defines conduct as to lead or guide, to convey, to direct, to manage, to behave, to carry or transmit a bit time for the coordinate, the act of method of living or managing. Now, my lord, 12.3. As such, it is clear that the meaning which can be ascribed to the term not conducting or wrongly conducting as specified under Section 40, subsection 4A will have to be understood to mean that a meeting was duly called for and the issues raised in the agenda were brought up for discussion and the resolutions thereon recorded in minutes, and such other requirements and procedures as may be prescribed by law adhered to. In the event a meeting is called for and the procedures mandated by the law are not adopted or followed as prescribed, then it will amounting to not conducting or wrongly conducting any meeting, including general meeting, special general meeting. Under Section 49(1) of the Act of the 2007, a chief executive of the society, by whatever designation, is to be appointed by the board or the state government. The chief executive appointed under Section 49 of the Act is under the general superintendence, direction and control of the board and responsible for the day-to-day management of the business of the cooperative, operating the accounts and making arrangement for safe custody of the cash, signing documents for and on behalf of the cooperative societies. Under Section 49(2)(e), it is the chief executive who is responsible for convening meetings of the general body of the cooperative society, the board and the executive committee and other committees and subcommittees constituted under the provisions of the Act, bylaws, and maintain proper record for such meetings. The power and functions are prescribed under Section 49(2) of the Act of 2007. Convening the meetings of the general bodies of the cooperative societies is inter alia one of the functions prescribed under the Act. In view of such specific provisions under the Act, it is the chief executive who is required to convene the meetings. In the facts of the present case, as is evident from the pleadings, it is seen that no meeting is prescribed under Section 39 was at all called for. As such, it cannot be said that any meeting was held and conducted as per the provisions of the Act of 2007. Consequently, since no meeting was held, the question of any meeting being conducted or wrongly conducted by the directors in the facts of the present case did not arise. in view of our findings that no special general meeting or annual general meeting having been called for as required under the provisions of the Assam Cooperative Societies Act 2007, the embargo prescribed under 44A will not be applicable to the appellants and the members of the erstwhile board of directors of so and so limited in the facts of the present case. So, my lord, what I have understood, essentially, my lord, the Honorable Division Bench says that if a meeting is called and if, my lord, the proceedings are wrongly taken, then, my lord, the embargo will, my lord, attract. When a meeting is not at all called, and when the secretary or the chief executive, who is responsible, my lord, for convening the meeting, if that was not convened at all, then the embargo, my lord, will not apply. If your lordship, again, my lord, read this one, what I have understood, my lord.
But you think you have understood something from this?
My lord, in fact, what I say, that as, my lord, the facts of the division bench case, my lord, here the facts are identical. What happened, my lord, the two factions, my lord, while they were fighting with each other, they lost sight of the fact, my lord, that the election is, my lord, knocking at the door. Now, the secretary, what he did, and this is my instruction also, my lord, he convened one meeting on 16/5/23. Now, for some reason, the meeting has to be abandoned abruptly, my lord. Subsequent thereto, my lord, no meeting was convened by him. My learned friend has pointed one meeting, which your lordship will find at page, my lord, page 85. If your lordship again comes to page 85 of the writ petition,
Yes.
saying that a meeting was called subsequent to 16/5. But interestingly, your lordship will see, my lord, what is the agenda. Agenda is not in respect of the election and AGM. Agenda is in respect of cash book.
So, Mr. Talukdar, what is the point you are trying to make?
My lord, the point which I'm trying to make, the division bench, my lord, has categorically said, when the fault cannot be
So
attributed.
you are saying that if a meeting is not held,
Yes,
then 39 will not come in. For
absolutely.
39 to come in,
Yes.
meeting has to be held, but it has to be not in accordance with the procedure.
Exactly what the division bench says, the holding of the meeting, my lord, the convening of the meeting is, my lord, on the secretary. So once the secretary discharges, my lord, his responsibility, then, my lord, it comes on the board of directors. This is what, my lord, the division bench has held. Because once, my lord, the meeting is not convened, then the, my lord, proceedings cannot be taken up by the board, or the, my lord, the burden does not come on the board. It does not start at all. This is what the division bench has said. If I again read it out, my lord, I'll try to understand, my lord. I may be wrong, my lord. Because 12.3, it is very clear. As such, it is clear that the meeting which can be ascribed to the term not conducting or wrongly conducting, as specified under 44A, will have to be understood to mean that a meeting was duly called for, and the issues raised in the agenda were brought up for discussion, and the resolutions thereon are recorded in the minutes, and such other requirements and procedure as may be prescribed by law are adhered to. In the event a meeting is called for and the procedures mandated by the law are not adopted or followed as prescribed, then it will amount to not conducting or wrongly conducting. If the meeting is called, if the proceedings are not, my lord, carry forwarded in accordance with law, then only, my lord, the embargo, my lord, will come into play. Not conducting or wrongly conducting any meeting, including annual general meeting, special general meeting. So this is what, my lord, this is categorical, my lord. In my respectful submission, this is very specific, my lord, and there is no room, my lord, for any ambiguity. So in the division bench judgment also, my lord, division bench has held the secretary did not discharge, my lord, his responsibility. No annual general meeting, my lord, was called for by him.
Is there any appeal or?
No, my lord, this has attained finality, my lord. This is binding on us, my lord.
With all respect, I am finding difficult to accept
Absolutely,
this
my
view,
lord. Absolutely.
but you have no choice. You have to prefer a review, revision or whatever. Otherwise, this judgment will come into play. Of course, what consequence it will have is another matter, but the registrar never knew about this judgment when he passed the order probably.
Yes.
But now he will take advantage of this. This is the interpretation given to the section, which I cannot, as a single judge, make any comment whether I agree. If it was a coordinate bench, I could have recorded my opinion and referred the matter to a larger bench. But
But your lordship will kindly see.
think about it, what you want to do.
I
Not
will-
much time. What do you want to do? We can keep it pending. You prefer a review if you want before the division bench and get it verified. But or otherwise, the course would be to dismiss it by relying on this judgment so that you can. What is to be done? You have seen this judgment.
Lordship, right now, your lordship, I have gone through it.
Go through the judgment and tell us what to do.
Lordship.
It seems some interpretation of the statute has been recorded.
Lordship.
12.3, my lord.
So 12.3. I will, your lordship, go through and your lordship come back.
Don't be
I have-
emotional.
No, your lordship, there is no question of being emotional, but your lordship,
This
I
is
will
the
try to,
division bench judgment.
lordship, but your lordship, I will try to, your lordship,
I
distinguish my facts. your
can't
lordship
say
also.
that
Correct.
the principle are wholly agreeable, but then this is binding.
Lordship.
If your lordship permits me another submission, my lord, I have. My lord, what I say that improper rejection or acceptance, my lord, being, my lord, subject matter before the tribunal. And in terms of Ponnuswamy's case, my lord, writ petition is not maintainable. Because the
No, in
expression,
that case, we'll give them liberty and ask the returning officer to decide it without being influenced by the order of the,
Lordship.
huh?
Lordship.
That you want
That
to do?
can be your lordship option.
You challenge it
Lordship.
without being, you have to challenge it before whom? The tribunal,
Tribunal.
election tribunal.
Election.
election
Then the
authority.
tribunal will decide it without being influenced by the impugn order dated 01/09/2023. In that case, you don't get into these technicalities.
Lordship.
Otherwise, are you agreeable to that?
Lordship may take it up, your lordship, day after tomorrow, your lordship.
Day after I'll take it up, but day after the matter cannot be heard further. Then it will go after vacation.
Day after tomorrow, your lordship, if I will also take instruction, your lordship, since it's an matter, your lordship.
All
I will
right,
have to-
take down in item 5, we heard Mr. S. Bothakul and counsel appearing for the writ petitioners in item 5. Also heard Mr. S. Hawk, learned counsel appearing for the writ petitioner in item 4. Mr. S. K. Talukder. Yes?
Or your lordship may immediately fixed on reopening, your lordship.
That
Only
approval,
thing, your
lordship
lordship,
will
I am.
vacate
I
the
am
interim
not
order.
making
I have no
straight-
problem taking time by my learned friend. Lordship, my lord, in the meantime,
No,
because,
there is no question. Either I'll dismiss the writ petitions or dispose it of or allow it.
yes,
Any three of these options will happen.
Yes.
Suddenly, who has applied for a vacation of the interim order? Who has applied?
no, in fact, my lord, under the, my lord, section 45.
Has anybody applied for vacation of the?
No,
interim order?
I'm not on that. My lord, what I'm on, my lord, under 45, there is a requirement of approving within 15 days from the date of election, my lord. That is why.
That's
saying.
your lordship.
There is a
order when-
statutory prescription, my lord.
When your lordship is
If
session
there
of
is
the
a court
matter.
order.
No, I'm not. I'm only just, my lord, saying that, my lord. Yeah, it's a lordship discretion, my lord.
You challenge the election.
Lordship.
Mr. S. K. Talukder, learned, Standing Council Cooperation Department, Assam, appearing for the official respondent. Mr. M. K. Hussain, learned, council is present on behalf of the official respondents. Private respondents. The order dated 01/09/2023 passed by the Register of Cooperative Societies permitting the private respondents, some of the private respondents, namely the respondent numbers 7 to 15 in WPC number 5400/2023 to participate in the AGM oblique election of the cooperative society নাম কি দিব of the
Dhopaguri or
Dhupaguri Samavai Samiti Limited held on 17/9/2023 has been put under challenge in both these writ petitions instituted by some of the shareholders of the committee who had also taken part in the election process. First up, according to the writ petitioners, the private respondents who had participated in the AGM oblique election are a part of the board, are part of a previous board whose term stood dissolved by operation of section 39 of the Assam Cooperative Societies Act 2007, and therefore in view of the specific provision of section 41(8) of the Act of 2007 read with clause 23 bracket (KA) bracket close bracket 2 bracket close of the bylaws of the society, they were not eligible to take part in the, they were not eligible to seek re-election. First up, on such ground, Mr. Pottakur submits that this is a clear case of improper acceptance of nomination of the said respondents, despite being ineligible to participate in the election under the law. Full stop. The learned counsel for the petitioner has further argued that the writ petitioners were precluded from filing their objection before the returning officer as per the prescription of the statute in view of the impugned order dated 01/09/2023 passed by the Register of Cooperative Societies, permitting the private respondents to participate in the AGM stroke election on grounds which were completely irrelevant. First up, the impugned order dated 01/09/2023 has also been assailed by the petitioners on the ground that the same is dehoes the provision of law in as much as the Register of Cooperative Societies does not have any power vested under the statute to pass such an order. First up, responding to the above, Mr. Talukdar has argued that if the petitioners are aggrieved by acceptance of the nomination filed by the private respondents, then the remedy would lie in filing an election petition under Rule
27, my lord.
Rule 27 of the
Assam Cooperative Society Election Rule 2019.
Assam Cooperative Society Election Rule 2019. Insofar as the exercise of power by the Register of Cooperative Society is concerned, Mr. Talukdar has placed reliance on a decision of the division bench of this court rendered in the case of Zahirul Islam Laskar and others versus Bakhtar Hussain and others. Bracket, they were writ appeal number 31 of 2019. 2019 to submit that by interpreting the provision of section 39 and 41 bracket 4 bracket close bracket A of the Act of 2007, this court has already held
My lord,
that
41 not, my lord, 44A.
44A of the Act of 2007, the division bench has held that the responsibility of convening the meeting is upon the secretary of the committee, and therefore merely because the AGM was not convened, the board cannot be held responsible. To that extent, the view of the register cannot be faulted in the eye of law. The question as to whether the decision in the case of Zahirul Islam Laskar bracket Supra would be attracted to the facts and circumstances of this case is a matter that would require independent examination. However, viewed from any angle, since the election has already been held, the election of the private respondents can be called into question by filing an election petition. That too, if it turns out that any one or several of them have been elected in the AGM. Full stop. It is not in dispute that the results are yet to be declared, and the same is pending due to the interim orders operating in this case. Full stop. Situated thus, without expressing any further opinion on the merit of the claims and counterclaims of the parties, the respondents are granted liberty to declare the results of the AGM stroke election of the Samiti, and thereafter take appropriate steps in the matter in accordance with law. Full stop. The petitioners would be at liberty to call into question the election of any of the private respondents due to, on the ground of improper acceptance of nomination paper, if so advised. Full stop. If such election petition is filed by the petitioners or any one of them, the same be decided on the merits of the case without being influenced by the impugn order dated 01/09/2023 passed by the Register of Cooperative Societies. With the above observation, both these writ petitions stand disposed of. Yes,
Only one aspect is there, Your Lordship. Section Rule 27 says, Your Lordship, any dispute relating to election of cooperative society may be submitted within 3 days from the date of declaration of results, Your Lordship.
the
That
result
is,
has
the
not
results
yet been
has not
declared.
been declared.
Since the results of the election are yet to be declared, hence the question of limitation in presenting the election petition will be governed under the statute with effect from the date of declaration of the result. It is clarified will be given. But Mr. Talukdar,
I understand. Malad, I cannot comment, Malad. Oblige, Malad.
Oblige the rules.
For hearing item 6.
Wait, please. What if the matter pertains to non-payment of contractual bill, my lord?
contractual bills is 2013.
Hello.
Lordship in from 2007 onwards, Lordship.
My lord, they file a reply in this case, my lord.
Lordship,
Why the bills have not been paid?
Lordship, all the bills are paid except 2 bills, Lordship, which our stand is that we have never received the bills. So since we have not received, Lordship, how can we pay?
My lord, kindly, my lord,
Just a minute, 2 bills of what amount?
Of Lordship, in total, it amounts to around 1,05,866 as per their claim, Lordship.
And
The rest is paid.
you also agree with that, except 2 bills?
it's not paid till date.
Huh?
Till date not paid, but we have raised it, my lord. Can you see annexure 5?
Listen,
Yes.
listen to the question. He is saying all other bills have been paid except 2 bills.
Yes, yes.
The amount involved in wind is 1,05,860.
True.
That you agree.
Yeah.
So you submit fresh copies, they'll examine and
Yes, Lordship.
take appropriate step.
Yes, Lordship.
Take down hard, Mr. Roy. A. Royal and Council appearing for the writ petitioner. Also heard Mr. D. Upamanu, learned SC, Health and Family Welfare Department, Assam, appearing for the official respondents. First up, the writ petitioner hearing was earlier awarded the work of providing security at the Guwahati Medical College and Hospital, Guwahati, on payment of charges. Full stop. The period of contract was in between October 2007 till 15/5/2012 without any break. Full stop. After completion of the work, the petitioner had submitted bills for payment of its of its contractual dues. However, alleging that the bill amounting to rupees 3,41,572 had not been paid to it for no valid reason, the instant writ petition has been filed. It's a proprietorship firm. So
Yes,
paid
ma'am.
to it, no, paid to him. The petitioner, which is a proprietorship firm, start with that. Not paid to him for no valid reason, the instant writ petition has been filed. First up, Mr. Upamanyu submits that during the pendency of this writ petition, all bills of the petitioner, the copies of which were available in the office record, has been cleared. However, in respect of the amount of rupees 1,05,866.
Well,
But-
two
Huh?
bills were there. One is 99,528 and 6,338, my lord.
That's it. That's what I'm writing. Why
Yes.
are you disturbing?
I'm
the-
sorry. ma'am.
1,05,866 pertaining to two bills. The submission of Mr. Upamanyu is that no such bill had been received by the
Hospital authority.
hospital authorities. And therefore, the question of processing the same did not arise. First up, although Mr. A. Roy Leonard, counsel for the petitioner, has disputed the said submission by contending that all bills were submitted before the authorities, yet he has agreed to furnish fresh copies of the two bills for processing the claim of the petitioner. If that be so, this writ petition is being disposed of by providing that within 2 weeks from today, the petitioner shall submit the
Bill
two
number.
bills afresh before the respond number 3, that is the superintendent of Guwahati Medical College Hospital, Guwahati. First up, on receipt of the bills, the same will be verified, and if found to be genuine, necessary steps for release of the amount shall be initiated within a further period of 6 weeks. With the above observation, the writ petition stands disposed of.
Oh,
Highly obliged.
And on verification of the bill, if it is found to be genuine,
If
not
not already paid, lordship.
oh,
if not already paid.
Highly obliged.
obliged.
Last two words will be. not repeated. Writ petition stands disposed of. Yes, what is this?
The petitioners herein, my lord, they claim themselves to be riots, my lord. And the land in question, my lord, was acquired by the state under the, my lord, some state acquisition of Zamindaries Act. Now, my lord, they are challenging, my lord, decision of the SDLAC, whereby the land in question over which the petitioner alleges to be in occupation has been allotted, my lord, to Kasturba Gandhi Vidyalaya. That affidavits have not been filed here, my lord, we are awaiting the instruction. But if my lord peruses the admitted position, if my
You want to
lord,
file affidavit?
my lord, an affidavit will be required, my lord.
All right. None appears for the petitioner when the matter is called up. Mr. R. Bapujari, Learned SC Revenue Department, Assam submits that due to want of instruction, no affidavit could be filed in this case. However, the Learned Department Council has prayed for 4 weeks further time to file affidavit. In view of the request made at the bar, hearing of this matter stands adjourned for 4 weeks so as to enable the departmental authorities to file affidavit. Ms. S. Borwa, Learned GA Assam, you are also there? Mr. B. Chaudhary, Learned, you are appearing for? Learned SC, Standing Council SSA, are also present on behalf of the official respondents. This recording, yes.
May it please your lordship, the instant petitioners were operating their shops on the Sabwa Town Committee in a market which was being operated by the Sabwa Town Committee. And what happened, your lordship, in the year 2010, those shops were demolished
and these were reconstructed. Our only plea was that we are operating the shops on the ground floor because these are basically the vegetable vendors and the fruit vendors. So they have been allotted the shops in the first floor. So we told that we will not be able to continue with our business in the first floor. So we should be given a shop in the ground floor. So accordingly, when we are not allotted, your lordship, we approach this honorable court. The honorable court initially passed an interim order in our favor, directing that the shop should not be allotted. If your lordships kindly see, peruse the order dated 6/6/2014. That's the last para. In the interim, the Sabua Town Committee is restrained from allotting any further shop rooms in the new market building without considering the petitions if they were actually operating their business in the Sabua Sohit Bazaar by paying rent to the Sabua Town Committee. So our instruction as on date is that we have not been allotted with the shops, your lordship. And one of the petitioner, Mr. Golab Ali, he already expired, your lordship. So our basic grievance is that we may be allotted a shops so that we can run our day-to-day business. As of now, we are running in the street vendor somewhere else, or some are working as a daily wage.
But we can't tell them where to allot the shop, with the ground floor, first floor, that we can't say.
I leave it to your lordship.
You are appearing for whom?
I am appearing for the respondent number 2 and 3, municipality.
Consider their applications for allotment of shop.
No, here, your lordship, the earlier shop was having 111 shop. Two buildings, there are two buildings, and in the ground floor 111. Then we have constructed one building. In this one building, only 81 found in the ground floor and 69 in the second floor. So we cannot allot it to 111.
So wherever you can allot, that's all. If they are not happy, then we'll see.
No, we have already allotted in the second floor.
First floor, as per the.
First floor.
First floor.
In the first floor.
Take it first floor. You take
Yes,
it.
your lordship. So,
Yes, your lordship, but let them allot us. That's the only.
now we have already, there is the vacant positions. They didn't approach. So because of that, we could not. But
So there are two writ petitions, is it?
but in this case, in this case, one thing has happened, your lordship. That is the municipality town committee, Sabua town committee become the municipality board in the year 2018.
Whatever, this will
Whatever.
continue.
Yes.
No, the prayer, may I just make a prayer if your lordship, permit me, your lordship? If they can accommodate us in the ground floor, if there is
No.
something, at least the vendors, your lordship, nobody will go to purchase fruits and vegetables to the first floor. So if they can,
Who has been given the shops in the ground floor?
only one person was given, your lordship, Gulab Ali, but he expired long back, your lordship. In item number 8, I am making submission in item number 8. Gulab Ali expired 8 years back, your lordship. So as he was allotted, but he could not turn up to accept that. I have taken
Gulab
the-
Ali is a petitioner.
Yes,
Yes,
petitioner
one of the
number,
petitioner.
petitioner number, your
Two.
lordship, 2. So he expired, your lordship. Maybe his family can run it, your lordship. He was a fruit vendor, your lordship, in that case.
No, Mr. Sinha, you are contradicting yourself.
Yes, your lordship.
If you want that the court should adjudicate whether it is ground floor or first floor,
Yes, your lordship.
then it is another matter.
No,
Then
I'm not,
we'll hear it in due course.
no, I'm not on that, your lordship.
Then otherwise, your applicants, he's saying they will allot whether it is in ground floor or.
Or the
floor.
first floor, yes.
Wherever it is suitably, they will allot
Yes,
Yes.
by keeping in mind the nature of business activities carried
yes,
out
your
by
lordship.
them.
That much will do. Yes, your lordship.
Take down hard Mr. R. Sinha, Learned Counsel for the writ petitioners in item 8, and Mr. G. Uddin, Learned Counsel for the petitioners in item 9. Mr. A. Upadhyay.
NN
NN
Upadhyay,
Upadhyay, Learned Counsel is present on behalf of
2 and 3.
the respond numbers 2 and 3. Whereas Mr. Mr. S. Burwal and G. Assam is present on behalf of respond numbers 1 and 4. Full stop. The writ petitioners in both these writ petitions were carrying on business in the Chabua Swahid Bazar. By occupying space based on individual agreements entered into with the Chabua Town Committee, bracket, now reconstituted as
Sabua Municipality Board.
Chabua Municipality Board. Full stop. In the year 2010, the old Assam type house, the old Assam type houses standing in the market were demolished and were demolished for the purpose of construction a multi-storied market complex on the same site. Full stop. Assurance was given to the earlier vendors that they would be accommodated on priority basis in the new building. Accordingly, the vendors, including the writ petitioners, had voluntarily relocated their business so as to facilitate the construction. However, after the new complex was constructed, no accommodation has been provided to them by the committee stroke municipal board of Chabua, town committee stroke municipal board of Chabua, as a result of which the petitioners had to approach this court by filing the aforementioned writ petitions. First up, it is the submission of the petitioners' counsel that their clients are mostly vegetable / fruit vendors, and therefore, unless shops are allocated in the ground floor, it would be practically impossible for them to run their business. Full stop. Responding to the above, Mr. Upadhyay has submitted that all the petitioners would be allocated shop rooms in the newly constructed complex, but it may not be possible to accommodate the petitioners in the ground floor, since the number of shops in the ground floor of the complex is limited and there are prior obligations of the committee with regard to those shops. First, be that as it may, since the only grievance of the petitioners is to the effect that they should be allocated suitable shop rooms in the newly constructed market complex, and considering the assurance given by Mr. Upadhyay that such allocations will be made without further delay if an order is passed by this court, these writ petitions are hereby disposed of by providing that the claim of the petitioners for allocation of shop rooms, suitable within quotes, suitable shop rooms in the newly constructed complex shall be considered objectively by the authorities, and thereafter necessary steps in that regard will be taken without undue delay. Full stop. In doing so, the authorities will also keep in mind the nature of business activities conducted by the petitioners, and if possible, shop rooms in the ground room may also be allocated to them, subject, however, to the availability of the same. With the above observation, both these writ petitions stand disposed.
Deeply obliged, Your Lordship.
May I please, the Lordship. My lord, there are two matters. One is filed by us writ petition against granting of mutation order, and another has been filed by the respondent RFA, that is 69/2018. Lordship, the story of the case is like this, my lord. This is a church. The present writ petitioner is a church, a Northern Lutheran church. They have a vast plot of land at Bongaigaon town, and one person, Bandhuram Musahari, my lord, he was there as a pastor, but being influenced by some other persons, he made a plot of land within that church property in his own name, mutated his name. That was not known to us. It was the that was not known to us. It was done in the year 1995. Secretly, they did this in collaboration with certain.
No, just a minute. There is a writ petition and there is a RFA, regular first
Yes.
appeal. Who is the appellant's counsel?
Lordship, I am that.
You are the appellant's. The RFE is regarding what?
Lordship, we are aggrieved by the findings in issue number 1, 2, 3, 4, 5, 7, and 8.
You are the plaintiff or defendant?
I am the defendant, Lordship.
You are the defendant.
Yes, Lordship.
Suit has been decreed.
Yes, Lordship.
Who has filed the suit?
Suit has been filed by.
So our suit was allowed and their claim over that plot of land was dismissed. So our right title interest was established, he got nothing. Then he filed the appeal and that was bypassing that order without our knowledge. Again, they did some plot of land.
So we'll hear the appeal first. If the appeal is allowed, then
Yes,
this
that-
order will
we
say
have to- we
the
have to-
appeal is dismissed.
We have no objection.
So you argue the appeal. Yes. Let us see what is the plaint.
Link is at Lordship. Lordship, page number 51.
Page number 51, yes. What is the valuation of the suit?
Lordship, 5,00,100.
So is this a matter to be first appeal to be heard by the High Court? Is the first appeal to be heard by High Court? Check out.
At that time,
No, now we'll go by what is the position now. Let's call it. Please check it out. I'll come back in 5 minutes. It's a question of jurisdiction. If it is to be heard by High Court, we'll hear it. If it is not, then we'll send it back. We'll send it back and in the writ petition, we'll say that will be subject to further order passed in the appeal. For now, status quo is to be maintained. There is no other option, Mr. Mahmood. If the court can hear the matter, we'll hear it. If we cannot, we'll send it back. So you.
There is another court.
Huh?
Another court.
Another court. Take down heard Mr. C. Sharma, learned counsel appearing for the appellant. Also heard Mr. M. Mahmood, learned counsel appearing for the respondent. This appellants and respondent. This first appeal from decree passed in title suit number 40/2012 by the learned civil judge Bongaigaon has been this first appeal against the decree dated against the judgment and decree dated
Lordship.
it is writing like this. His first appeal is directed against the judgment dated 25/1/2018 and decree dated 30/1/2018 passed by the learned civil judge Bongaigaon in title suit number 40/2012, decreeing the suit filed by the respondent as plaintiff. Full stop. Today, the matter is called up for final hearing. However, on going through the records, this court finds that the appeal is valued at rupees 5 lakhs, and as per the standing notification issued by the registry, only appeals which are valued at 20 lakhs and above are to be heard by the High Court. Only the first appeals which are valued at above, only the regular first appeals which are valued at above rupees 5 lakhs, which are valued at rupees 5 lakhs and above are to be heard by the High Court. After the amendment of the after the amended circular pertaining to jurisdiction of courts to hear appeal has been issued. In view of the above, registry to examine the matter, and if it is found that the appeal is to be heard by the Court of Learned District Judge Bongaigaon, the records, including the LCR, be transmitted therein without any further delay. First of all.
Lordship,
Ah.
Lordship indicated that it's above 5 lakhs.
Hmm.
It's above 20 lakhs, Lordship. High Court jurisdiction is above 20 lakhs.
About 20 lakhs. Yes. About 20 lakhs. Hmm? It cannot be treated as dispute. It has to be sent back.
Remand.
Record has to be sent back. And what about the writ petition?
With petition, go ahead.
Writ petition, Lordship, I am for the private respondent number 5, Your Lordship. They have challenged the mutation order and which was upheld by the Board of Revenue. They have challenged the final order of the Board of Revenue in the writ petition, Your Lordship.
So where is Mr. Mahmood?
Lordship, my senior liaison on code number 17, please. Time after some time.
No, this is a matter which was going on.
The order is that impugned order is at Annexure 7, Your Lordship, page 34.
So is it connected with the appeal?
This order was passed prior, same land, Your Lordship, same plot.
Same land.
Same plot of land. But this order was passed prior to the institution of that suit, the title suit itself, Your Lordship.
No, the decree is in favor of the
Yeah,
writ
prior
petitioner.
to that, there was another round of litigation whereby the suit and the counterclaim both were dismissed, Your Lordship. After that, they appeared before the revenue officials for cancellation of my name from the record of rights, which was turned down. They approached the Board of Revenue. Board of Revenue also turned down their request, their petition, and they approached this honorable court by filing the writ petition. In the meantime, side by side, they have also filed a title suit, which was ultimately decreed in their favor, Your Lordship.
So the records will now have to be corrected as per the decree.
As per the decree, and if anyways, the appeal is pending, Your Lordship, because appeal is a continuation of the suit, Your Lordship. Anything that outcome of the appellate order is there, Your Lordship, then we have to
So
be subject.
where is he? You call him. I'll pass an order after half an hour. Tell him to come. There is one more matter before rising. I'll pass an order. Please wait. He has left the court after when the matter was going on. Then that order you write, it has been brought to the notice of this court that after the recent amendment of the Bengal, Agra and Assam Civil Code Act 1887, appeal from judgment in decree passed by the civil judge, bracket senior division, where the value of the original suit oblique decree does not exceed rupees 20 lakhs, comma, would lie in the court of district judge, and those exceeding the value of 20 lakhs would come to the High Court. First up, since the suit out of which the present appeal arises is valued at rupees 5 lakhs, it prima facie appears that the appeal would have to be heard by the learned district judge Bongaigaon, registered to verify and do the needful for transmitting the records, including the LCR, before the competent court for hearing of the appeal as expeditiously as possible. This will be the order there. party's name and all will be same. Yeah. But you be here, there is one more matter, is it? After that, we'll take up that case.
May it please, your Lordship. Lordship, I'm appearing for the respond number 2 in this matter. This is an old matter, also 2014. We were being led by Mr. Niladatta, your Lordship, in this matter. He expired, my lord. So, my lord, it's come after, my lord, last it came on 2015. So, my lord, the client
There
was.
is no adjournment in this matter.
My lord, we'll be engaging a council, Lordship, senior council.
What is the matter, Mr.?
My lord, in fact.
Mr. Fukan, these are matters which are written as top of the list.
My lord,
You should know that there will be no adjournment.
My lord, actually, my lord, we have actually, my lord, we don't have the file also, Lordship. After a long time, the one
He was asking me to serve the, my lord, the copy of the.
reconstruct, my lord. We were actually, that's why, my lord.
He informed me.
Usually it doesn't happen, your Lordship.
I heard Mr. M. K. Chandra, senior counsel appearing for the petitioner, also heard Mr. A. Fukan, learned counsel representing the
Respond number 2, your Lordship.
respond number 2, who submits that the senior counsel earlier engaged in this case has expired and the case records are also not presently available with him. As such, Mr. Fukan has prayed for posting this matter again after the reopening of Puja vacation so as to enable him to make necessary arrangements. Mr. S. Bora, learned SC. GMC is present on behalf of the official respondent. Since the prayer for adjournment has not been opposed and considering the ground on which the prayer is made, although this is a very old pending matter, the prayer stands allowed. Registered to list this case again in the 3rd week of November 2023 for hearing as a matter shown in the top of the list. It is made clear that no further adjournment will be granted in this case.
Deeply obliged. Deeply obliged.
Yes, let us see what is the matter.
Lordship, the impugned order is at page 34, annexure 7, your Lordship.
1 minute, I'll just go through the record.
My lord, I will explain sorry, point
Yes,
number
yes.
7 was repeatedly passed.
No, it's all right. Mr. Mahmood, the appeal cannot be heard by the High Court. High Court now, after the amendment of the Act, this is a statutory
Yes.
provision.
Recently, it has-
Over 20 lakhs and above only High
Yes,
Court
yes.
can hear. So we have sent the appeal.
the district of Bongaigaon.
Yes, as far as your writ petition is concerned, after the order was passed, then the decree came in. So therefore, the decree will now govern
Yes.
on rights, the
If his
record of
right is
rights.
established, our case goes. If face, then.
So it will be governed by the outcome of the
Yes.
appeal. So by clarifying that, we'll close this matter.
Yes.
Nothing can be done at this stage. What is the point in hearing? Because
Yes.
if the.
First, the jurisdiction question has to be settled. Jurisdiction question has to be.
That's
settled.
right, that's right. So I'm passing that order.
But Lordship may kindly fix a time because it's trust property. We are suffering. A timetable may kindly be.
No, as expeditiously, I've said, and that is in the other matter. We take down out Mr. M.U. Mahmood, learned counsel appearing for the writ petitioner. Also heard Mr. Who is
BJ
appeal-
Mukherjee.
Huh?
BJ Mukherjee for 5.
All right, Ms. G. Hazarika, learned SC Revenue Department, Assam, for respond number 1. Mr. S. Borwa, learned G. Assam, for respond numbers 2 and 3. Who is for 4, 5?
4 and 6 expired. We have intimated that long back. I am for 5 only.
And Mr. B.J. Mukherjee, learned counsel appearing for the
Respond
respond
number
number 5. Full stop. In this writ petition, the order dated 12/5/2014 passed by the learned Assam Board of Revenue in case number 24, capital R, capital A, bracket BNG, bracket close, capital BNG, bracket close, oblique 2014, affirming the order dated 22/1/2013 passed by the learned ADC, bracket R, bracket close, Bongaigaon in Miss case number 39/2012 has been put under challenge, entirely contending that the correction of revenue records by order dated 5/9/1995. When was the revenue record corrected?
It was corrected after order. That's
Correction
why
of
we said-
revenue record and the mutation granted in favor of the respondent number 5
Yes.
is illegal, full stop. However, it appears that during the pendency of these proceedings, the writ petitioner as plaintiff had instituted title suit number title suit number
40 of 2012,
30 or 38,
40 of 12.
40 of 2012 in the court of the learned civil judge, senior division, Borpeta. You see the case number, Chaudhary. Bongaigaon. Seeking declaration of right title and interest over in respect of the same plot of land wherein the private respondents were implicated as defendants, and the suit has been decreed in favor of the writ petitioner stroke plaintiff, full stop. The private respondents have preferred RFA number so and so dated so and so, which is pending disposal before the appellate court, full stop. Since there is a dispute as regards claim of title over the plot of land, the record of right would obviously have to be corrected as per the decree passed by the civil court after determination the rights of the parties, full stop. If that be so, it is apparent that the controversy involved in this proceeding would stand finally resolved only after the decree passed in title suit number so and so attains finality in the eye of law. In view of the above, by providing that the entries in the revenue records would be made by the revenue authorities on the basis of the decree passed by the civil court in this case, this writ petition stands disposed of. Writ petition stands disposed of. As per the decree,
Yes.
that's it. What else? That's the order.
An alternative, may I say that it may be kept pending till the
All right, disposed of. Thank you.